Hello. You are about to watch a presentation for Business Law with UC San Diego Extension on HarperCollins Publishers. The presentation is by Donna Winnick Bollenbacher, Marta Levine, Sara Gammage, and Rebecca Shipman. So before we get to all of the law, we thought we'd give you a little background about HarperCollins Publishers. You probably already recognize the name from some of your favorite books, but it's kind of interesting because this company actually started all the way back in 1817 in New York City. It was created by two brothers named James and John Harper. It has now grown to the second largest consumer book publisher in the world and has publishing operations in 17 different countries. The company has published books in every genre, and some of its famous authors include Madeleine Albright, Martin Luther King Jr., and Shel Silverstein. The company also supports a lot of foundations, especially in education and literacy nonprofits. Some of those include the National Book Foundation, the Author Leagues Fund, Operation Backpack, and Change for Kids, just to name a few. So to start us off, I will be discussing employment and labor law. So the focus on this is more how are the employees within this company protected. We're going to focus on the authors a little bit later, but this is as a whole. You have a company, what about your agents, your secretaries, everybody? They need to be protected, and that's where this kind of law comes in. What is employment and labor law? This is essentially what governs the relationship between employers and its employees. The relationships are traditionally governed by common law. Now, for a while, the common law was actually unmodified and it was more favorable to the employer. It left the employees with very few rights and protections. They were taken advantage of pay-wise, safety-wise, break-wise, anything you could imagine. These employers originally were able to get away with it. As time went on, things have changed. Now there's actually specific federal and state statutes to define the rights and obligations when it comes to employment law. Now I know that HarperCollins is based in New York and that's the focus on this presentation, but for the sake of the fact we're in California and we've been learning about California law, I thought it'd be important to mention with employment law, California is actually an at-will state. And what this means is that California, or an employer in California, can essentially come in and say, you know what, you're let go. They can fire you without cause, without notice, and not suffer any ramifications for it. So it's really important to understand what is protected under employment and labor law. And these are just a few. There's so much more to it, but I figured these were some of the more interesting ones. Workplace privacy, worker compensation, the standard stuff, health and safety, that's a huge one right now because of COVID-19. There are employment lawyers all over the place trying to make sure that if they represent these companies, that they are putting the health and safety above everything else. And there's also employment lawyers out there that are checking to make sure that if they have a client, their companies aren't going to basically screw them over and make them come to work without proper protocols and safety guidelines. Anti-discrimination protections is a big one. Recently, the Supreme Court did just pass that if you are gay or any form of the LGBTQ community, you cannot be fired for that. So that's protected under employment and labor law. Wage and hour requirements, making sure you're getting that proper pay, making sure are you exempt, are you not exempt if you're a salaried employee. That's extremely important. This one was kind of interesting. Human displacement. That essentially means that if they can bring in a robot essentially to do your job for you, that tech is going to take over your position, that you're protected by that. So that's, I thought was kind of interesting. That's a rather new area in employment law. Trade secret protection is a big one, ties in with intellectual property law, making sure your designs, your ideas, things like that are kept confidential. And another thing is the collective bargaining requirements. And that's actually what we're going to focus on as far as our document goes, and that's our area for employment law today. So the document I chose to draft for all of you is a collective bargaining agreement. Now, normally these things can go for pages and hundreds and hundreds and hundreds of pages. I promise I'm not going to do that to you. All I did was one section, and I'll get to that. But I wanted to start off with what is a collective bargaining agreement. That is a contract between an employer and the union. If you don't know, a union is an organization of workers. The collective bargaining agreement also regulates employees' working conditions. So it's going to go in and make sure that you are protected, you have your rights, all of that stuff. Terms are negotiated by the employer and representative of something called a bargaining unit. So what this is these are, you take your union, you pick a bunch of people from there, and they are your bargaining unit. And it is a federally certified group of employees authorized to engage in negotiations. So you are giving these people permission to go represent you to your employer. And I picked this cartoon. I thought it was kind of interesting because I don't know if you can see at the bottom, it says, "Can you do another draft of this?" There's still a couple of sentences people might actually understand. And unfortunately, from my research, I've read a lot of companies try to get away with this, actually. You think it's funny, but in all seriousness, they do try to put language in there that can kind of screw someone over. Either or. Either it's the employer trying to screw the union or vice versa. It's never just one-sided. So I thought this comic was very appropriate for the situation. So this is a look of a very, very toned down collective bargaining agreement. All I have here is the preamble and essentially one section. That's it. Like I said, there can be hundreds of pages, dozens of sections, but I'm not going to bore you, and that's not fair to the rest of my group to take up that time. So, starting at the very beginning of a collective bargaining agreement, where do we start? Basically, all the preamble says is, hey, we understand an agreement is being made, and here's the goal of that. And then you name the parties that are involved. In this case, because we're HarperCollins Publishers, and then throughout the rest of it, you can say will be known as publisher. And I actually researched HarperCollins Publishers Union is UAW Local 2110. They actually do have a union, so for the sake of this presentation, I went with the actual union name. And I picked this meme just because for some reason when I was putting the slide together, the song from Sound of Music popped in my head about starting at the very beginning, so I thought it was appropriate and something funny to enjoy. Okay, so this one section that I created for you guys is all about dues deduction. When you're part of a union, you don't just get a free ride. You have to pay your way through it. And that's why a lot of people don't tend to necessarily want unions, because they think, I'm just paying and I'm not getting anything out of it. When in reality, you actually get a lot of protections from a union. So some of the dues, the way it works is it's money taken from your paycheck. It's usually a preset amount within the agreement. So it covers your membership and it covers benefits that are provided by the union. So let's say something happens on the job and you're getting called into the boss's office or you need representation. If you're part of the union and you're paying your dues, you call them and they're going to send a rep to help you out. Some will send a lawyer if you need a lawyer. Some are going to send a rep to make sure you're not getting in trouble for something you shouldn't be getting in trouble for. That's what the union is there to do. They're there to protect you. So that kind of goes into a little bit about what the dues cover. Now, there's usually a union treasurer. They decide the amount, and then they're the ones that do the negotiating within the agreement. And if there's going to be any type of change to the rate, you have to give a 60-day notice. That's what I did in this agreement, because in my research, every agreement I looked at had that language that changes to the rate must be given with 60 days notice. That is extremely important so people can plan and be prepared if more money is getting taken out of their paycheck, because sometimes it can be a significant percentage that gets taken on top of taxes. Let's say you come into HarperCollins and you decide, you know what, I don't want to do the union. I don't like it. I don't want it. You're still going to have to get money taken out, and this is called a fair share fees. So while the money taken out of your paycheck is not as much as a union due would be, you still have to contribute towards the union itself. So what it is let's say your union due is 10% of your paycheck. That's how much your coworker is paying. But you don't want to do that. You want a fair share fee. Yours might only be 6 or 7. It depends on what's negotiated. Now, the reason you still have to pay is because the union essentially has to keep its lights on. That's what you're contributing to, so you have to help with that. You can't just work at a company that has a union and go, I'm not part of it. It doesn't work that way. You either help keep the lights on or you actually become part of the team. It's either or. Now, by paying your fair share fees, there are some things the union can't use your money for. They can't use it for litigation, public relations, lobbying, things like that. If the union wants to do that kind of stuff, they have to take that from the union dues because those topics, those things are directly impacting union members. So it's not fair or even legal to take money to benefit the union in the sense of progress by taking money from people that it wouldn't be helping to begin with. The union is also required by law to provide the information on how those fees were spent. So if somebody goes to them and says, I want to know where my money went, legally they have to hand you the piece of paper and you can see what's going on. Now, something you'll notice is within the last 2 slides, the contract doesn't specifically have a number for either union dues or fair share fees. The reason why is they prefer not to put actual numbers in these type of agreements. If, let's say, something in the middle of the year changes and there's a hard set number in this deal, they have to then go back to the drawing board, and that's just going to cause a big mess. So what they tend to do is they leave it out, and they have a clause in here that even says that, hey, the treasurer for the union is going to decide, and then they're going to let the publisher know right away. So that's in the clause to protect themselves. So something I found interesting is a clause that are in a lot of agreements, and I actually found this in a HarperCollins bargaining agreement, was for a lot of people, actually going and paying into a union is against some people's religion. It may sound strange, but it's legitimate. People do feel something like that goes against their beliefs, and obviously they don't want to do anything, the company doesn't want to do anything that's going to offend them. So what you do is you don't pay your union dues and fair share fees. However, you do still need to do something. So they've made an agreement. And in here it says that the employee must make a charitable donation for each paycheck. So it's going to be the same amount that a union due would be. So if it's 10% of your paycheck, someone's paying for their union dues, you need to do 10% of your paycheck and donate it to a charity. You'll work with the union to come up with an agreed upon charity. What you have to do is the union's not going to stay on top of you about this, in the sense of they're not going to pull the money out for you. You're in charge. So if you're going to go about this and you're able to prove it's against my religion, I'm not joining the union, I'm not paying fair share, then you're going to prove to the union, and you're going to show them once a month. You're going to send them copies and say, look, I took 10% of my paycheck and I did it. So that is something, if you're going to choose not to be part of this because of religious reasons, there is still stuff you need to do legally. So who is responsible for making sure all of this happens? So HarperCollins is responsible for sending the money each month. They're the ones that are pulling it out of your paycheck, not the union. The union is trusting, in this case the publisher, is trusting them to follow the agreement and pull that money out. As soon as that money is pulled, they then send it to the union or the union reps within 10 days of that deduction. They have to do that. If they don't, issues happen. You also need to have a list of members and then what their deductions were. So in this case, a list of employees. Are they a member? Are they paying fair share? Or are they doing a charitable donation? You have to submit that so the union is aware of who is working under the HarperCollins Publishers name. And of course, nothing is ever formal without a signature. Simple HarperCollins signs, and then in this case, UAW Local 2110 will also sign. So that's what I have as far as employment law and collective bargaining agreements. I hope you enjoy, and now I'm going to send you over to Marta with contract law.
My name is Marta Levine. This section will deal with a contract between HarperCollins Publisher and the author directly. I would like to start by giving a little background on what a contract is, the elements that give validity to a contract, the laws that govern contracts, and then going to the contract that we will be discussing today. Historically, Contracts have been the exchange of promises between parties, and they constitute the foundation of transacting business and building relationships. The primary purpose of a contract is to record the agreement of the parties. Contract law exists to regulate the obligations established by the agreement and to enforce the agreements of the parties. But who does contract law protect? In interpreting contracts, courts primarily focus on carrying out the intent of the parties. So it is safe to say that having a contract protects all the parties involved. If one party to a valid contract believes the other party has acted against their agreement, the party being harmed can bring lawsuit against the party who it believes has breached the contract. Now we will look at some specific aspects of the publishing contract we will be discussing in this segment. A contract holds both sides accountable for the terms they said at the start of the relationship. When a publisher and an author agree to work together, a connection that can last years is created, and it may last for as long as the involved parties continue to benefit from it. By nature, written contracts are a visual representation of that relationship, and they record the commitments of both parties. A contract between a publisher and an author is a bilateral contract. This means that both parties exchange promises to perform. One party's promise serves as consideration for the promise of the other. Once an offer is made and it is accepted by both parties, it can be said that they have mutual assent, meaning that the parties involved have agreed to the same thing and are prepared to enter into a valid and enforceable contract. Every party that wishes to enter into a contract with another is representing their own interests, and they come to the negotiating table with a set of their own expectations. Often, people in business believe that it is unlikely that misunderstandings will arise and do not pay enough attention to addressing them. Authors and publishers expose themselves to risk, legal trouble, and major losses when they do not have a signed, well-written contract in place that sets forth the parties' rights and obligations to protect them. Disputes between author and publishers over what was agreed can occur if they choose not to have a contract, or if the contract that they're utilizing does not specify the terms of the agreement between the parties. Additionally, a poorly written contract could mean that a court may not be able to enforce it when it is difficult to prove its terms. In the next few slides, we will look at a sample contract between HarperCollins and a book author. Here we have a list of the general clauses in a publishing contract. They are all important to mention for understanding a contract, but for the sake of time, we will focus on taking a closer look at the 4 highlighted clauses, since they are the areas that create the most conflict between publishers and authors. These are author warranties, grant of rights, author's right to cancel, and publisher's right to cancel. This is an example of what a contract between HarperCollins and an author may look like. In the next slide, we will be able to look at all the clauses that it contains, as well as an explanation of the 4 areas highlighted in this slide. We will now proceed to the contract breakdown. The grant of rights. When authors sign a publication contract, they transfer some or all of the rights to their publisher. The contract basically treats the rights of the author as a pie that can be cut into slices. Each slice is important to the author, and he or she must weigh the options for retaining control over them. The section about copyrights will be discussed in another segment of this presentation. In a grant of rights clause, the author transfers ownership of one or more of his or her rights to a new owner. This means that after the contract is signed, the author of the work no longer owns the parts of the work that were assigned by the clause, and can no longer exercise those rights or license them to someone else. For example, If the reproduction and distribution rights have been granted to the publisher, the author no longer has the right to make or sell copies of the manuscript without permission. This means that the author cannot, for example, make or distribute copies for a reading group or a class unless he or she has obtained the publisher's permission. The warranties and indemnity clauses. Publishers want to ensure they won't get sued for copyright infringement or other legal violations as a result of publishing an author's book. Publishers also want assurance that if they get sued, they will be reimbursed by the authors for any costs they incur during the suit and the payment of any damages that courts may award for legal violations. This is why publishers strongly insist on the inclusion of warranty and indemnification clauses in their contracts. Conditions for termination. The contract contains a section that includes language regarding termination of the agreement in the event of unsatisfactory performance by either party. In this contract, the author is required to return any advance payments that he or she may have received. It is important to mention that if a publisher opts for the dissolution of the contract, the copyrights to the work will revert to the author. Here is an example of how a contract protected the rights of HarperCollins. In a high-profile case in the publishing world, HarperCollins Publishers won a decisive victory over Open Road Integrated Media when a New York court ruled in its favor. The court deemed that the contract signed by the author of the book, though written many years ago, did address the assignment of the exclusive electronic publication rights to HarperCollins. How does a contract benefit each party? Let us look at a few of the key elements of why contracts are an important focus for any company. As we have seen, striving to have a bulletproof contract benefits each party involved. Additionally, here are other benefits of entering into a contract the right way and upholding the terms of such a contract. When the rights and obligations of both parties are clearly defined by well-executed contracts, business relationships are maintained, and less monies and resources are spent on resolving disputes that have ended up in court. The consumer indirectly benefits when keeping the cost of doing business low. There are 4 key takeaways from this presentation. Inconsistency and ambiguity in contracts will often lead to litigation. Agreements must be well thought out and drafted. Clarity is the key to a good contract. Weaknesses in a publishing contract must be addressed. Anyone interested in authoring a book and in getting it published should remember these important points. This concludes this segment.
Hello, my name is Sara Gammage, and I will be giving an overview of copyright law and how HarperCollins Publishers and another party might utilize a permissions contract. But first, we should define property. In defining property, there are 2 basic types. Real property, which is land or anything attached to land, such as buildings, fences, or crops, and personal property, which is all other property that is not real property. This could be your car, laptop, clothes, and furniture. Intellectual property is a subset of personal property, and it primarily consists of trademarks, patents, and copyrights. Trademarks are granted by the government through the U.S. Patent and Trademark Office. They protect words, phrases, names, or things that distinguish goods or services from those sold by others. Trademarks do not expire, though they do need to be renewed every 10 years. Trademarks are identified by an R with a circle around it. The TM you might be used to seeing denotes an unregistered trademark. Patents are also granted by the U.S. Patent and Trademark Office. They protect the property rights of inventors by preventing others from making, using, or selling the inventor's creation. Patents have different durations depending on the type, though most are valid for 20 years. Patents can also be identified by the letter R with a circle around it. as well as by a patent number that can consist of up to 8 characters. Copyrights are granted by the U.S. Copyright Office. They protect authors and creators of original works, which are defined as unique expressions of an idea. These works can be literary, musical, in audio or video formats. Even computer software is copyrightable. A registered copyright can be identified by the letter C with a circle around it. Intellectual property can be bought, sold, or licensed, and can be protected against theft or infringement by others. Copyrights exist from the moment a work is created in its fixed form. The work does not have to be published. Though it is not required, copyright registration affords benefits, such as establishing a public record of the copyright claim, which is a condition for bringing an infringement suit for works of U.S. origin. Copyright protection lasts 70 years after the death of the creator. The 3 basic requirements for copyrightability are: first, the work must be original, not necessarily first of its kind, but independently created. Second, the work must be in a fixed tangible form, meaning the form is a permanent object or recording. And last, the work must be a work of human authorship. The United States Code provides 8 non-exhaustive categories of the types of works that can be protected, including literary and musical works, choreography and pantomime, and architectural works. Some works are excluded from copyright protection. These can include facts, ideas, slogans, phrases, works in the public domain, which are works with expired copyrights, and government works. The doctrine of fair use permits limited use of copyrighted works without the permission of the copyright owner. Fair use covers use in parody, criticism, scholarship, news reporting, research, or for educational purposes. One of the rights afforded to copyright owners is the right to prepare or adapt derivative works, meaning a work based upon a pre-existing copyrighted work. The copyright owner has the right to adapt the original work, him or herself, or to include or exclude others from adapting the work, or even creating new works based on the original work. It should be noted that any new elements of derivative works are separately copyrightable from the original. Major publishers, such as HarperCollins, have in-house permission departments that facilitate requests from patrons to use copyrighted works published by them. This department executes permission contracts that allow users to reprint or reproduce works from HarperCollins U.S. books. It should be noted that HarperCollins, according to its permissions website, does not advise as to what falls under fair use. That is for the applicant to determine. Permission requests are accepted by mail, fax, or online. This is a screenshot of the online permissions request form at HarperCollins website. In addition to the applicant's personal information, the applicant must provide details of what work he or she would like to use and how much of that work, specifying the number of pages and the amount of words that would be used. Applicants must also provide details of where and how the work will be used. In this example, the copyrighted work will be used during a theatrical performance at a local high school. If the application is approved, a permission contract will be granted. Here is an example of what that contract might look like. It specifies what work is licensed, how the work will be used and in what form, its usage fee, and term or length of the contract. On this proposed contract, the licensor has granted permission for the licensee to use a single chapter of the young adult novel The Hate You Give, or the titled work. It should be noted the warranty states the work being licensed is protected by U.S. copyright laws and is registered with the U.S. Copyright Office. Taking a closer look, you can see how specific the contract is, and that only Chapter 2 of the book The Hate You Give will be used, or, as stated in the application, pages 20 through 24, approximately 922 words. The contract specifies how the licensee can use the copyrighted work. Here we see the work will be used in a theatrical performance at a high school. Having a contract such as this is essential for clarity. The two parties are aware of and agree to the expectations required of them. Both groups benefit from the agreement.
Next up, I'll discuss agency law. Agency law is the law that governs the relationship between a party and a person or entity it employs. The employer is the principal and the employee is the agent. The principal authorizes the agent to act on his or her behalf. Agency law allows principals to delegate tasks and responsibilities to their agents, which gives them time to expand their business or to see to other matters. Agency law can come from a written or oral contract between parties, or it can also be implied. The implied agency relationship occurs when two parties act like principal and agent in a way that a third party assumes the agent is working on behalf of the principal. Agency law sets up a fiduciary relationship between the agent and the principal. This means that the agent has a duty of loyalty as well as a duty to perform the tasks the principal gives them in a manner that the principal wants. I worked as a barista for a while, and part of my job was making drinks according to the recipes provided by my employer, not just how I felt like making them. In return, my employer had to pay me for the hours I worked and had to let me know about any potential harms. For example, I was given an apron to wear to protect my clothes, and I was given washcloths to protect my hands from potential steam burns. My manager was also an agent of our boss, and one of her duties was ordering ingredients and supplies for the shop. The shop owner was responsible for paying for the supplies, even though it was my manager who put each specific order in. This is because the principal is bound by the contracts an agent enters. While this never happened at my shop, theoretically, if one of the bakers put an expired ingredient in the baked goods and gave a customer food poisoning, the shop owner could be held liable for the damages done by the baker who is acting on behalf of the shop owner. So where do independent contractors fit in? Independent contractors are similar to employees because they are hired by an employer, but the employer is far more hands-off. As this cartoon shows, an independent contractor gets to set up their environment and has more control over how the job is done. An employee has much more employer oversight. Employers like to have independent contractors because the employer is not responsible for withholding taxes, paying for social security contributions, or providing benefits for the independent contractor. The downside is that the employer gives up some of their control as to how a task is carried out to the independent contractor. Independent contractors are generally not covered under agency law. Next, you'll see that the document I created is an independent contractor agreement between HarperCollins Publisher and the Sustainable Forestry Institute. In real life, SFI works with HarperCollins to make sure that they are using sustainable forestry practices. In my document, HarperCollins is hiring SFI to create and host a workshop for HarperCollins employees so that those employees can be better informed about the impact their company has on. So here's the agreement. It's pretty straightforward. The first paragraph outlines who the parties are and what is expected from SFI. Because it is an independent contractor agreement, many of the points are broad. This is because what HarperCollins expects SFI to do is take care of all the smaller details within the workshop. Point 3 states that the workshop must be done within a 6-week period unless the parties agree to change it in writing. There's a flat fee for the entire agreement in point 4. And an important element of the agreement is point 5 that states that SFI is responsible for its taxes, not HarperCollins. Some more parts of the agreement. Point 6 directs the reader to Exhibit B to learn what HarperCollins is providing to SFI, and point 7 lists how the contract could end. It also outlines what HarperCollins is responsible for paying SFI if the contract ends early. Just in case it was unclear earlier in the agreement, point 8 specifically states that SFI is an independent contractor and that the two parties are separate entities. They cannot act on behalf of or advertise as the other. This would be different in a principal-agent relationship. Like an employee to their employer, SFI still has to keep any confidential information HarperCollins gives them private. This privacy lasts beyond the end of the workshop. The final portion of the agreement outlines how the parties will resolve any disputes. That is, they'll try to solve them informally and in good faith, but if that doesn't work within 30 days, they'll do binding arbitration with the rules of the American Arbitration Association. Points 11 and 12 list that the agreement is complete and governed by the state of California. Point 13 sets out that if some part of a contract becomes unenforceable or invalid, say at the time of the workshop people are still not allowed to gather due to COVID-19 and social distancing guidelines, the rest of the agreement around the workshop still stands. That's not to say that the parties can't choose to update and change their agreement to react to this activity, so long as it's in writing. Lastly, SFI cannot decide that they don't want to be responsible for the workshop anymore and just give the agreement away to a different company. HarperCollins would have to agree and give consent in writing in order for the agreement to go to anyone else. In summary, independent contractor agreements are useful for companies that wish to outsource tasks to a different company or person that is better suited to handle said tasks. SFI is more knowledgeable and experienced in workshops in sustainable forestry, so it's a more efficient choice for HarperCollins to source this task to them rather than try to host the event itself. SFI benefits because it gets to work with a large and well-known company, and it has more freedom to plan the event. In doing so, SFI controls the information that is going out to the employees, and they are not severely limited by HarperCollins requirements. This would be different if HarperCollins assigned the task of a workshop creation to a group within its own company. If it had gone in that direction, the group would be acting as agents and would have to do a fair amount of external research and take time from their usual tasks to put on the workshop. The group may even have ended up reaching out to SFI in order to get more information about the topic. In employing a separate company to do something it specializes in, HarperCollins saved money and time, and SFI was paid for doing something that it's good at, and it got to shape the narrative to better inform people about sustainable forestry practices.
That concludes our presentation. We hope you learned a lot about HarperCollins Publishers and the different areas of law that they use to make the company run smoothly.